Good afternoon. This is the Supreme Court of the United Kingdom. We are continuing the hearing in the appeal by Shagang Shipping Company Limited and HNA Group Company Limited, and Lord Panic will continue his submissions. Lord Panic. You are now unmuted, Lord Panic.
I know.
You've just muted yourself.
Can you hear me now?
I can hear you, thank you.
Thank you very much. I was addressing the case of Read B, which is MS 1424, and I described the context in which that case arose. Can I deal with the paragraphs upon which the respondents, HNA, particularly rely? They rely on paragraph 2 in the speech of Lord Hoffman, which is MS 1430. And at paragraph 2, Lord Hoffman said, if a legal rule requires a fact to be proved, a fact in issue, a judge or jury must decide whether or not it happened. There's no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. The fact either happened or it did not. If the tribunal is left in doubt, the doubt is resolved by a rule that one party or the other carries the burden of proof. If the party who bears the burden of proof fails to discharge it, a value of 0 is returned and the fact is treated as not having happened. If he does discharge it, a value of 1 is returned and the fact is treated as having happened. And then paragraph 3, which is equally important, the effect of the decision of the House in Re H is that section 31(2)(a) requires any facts used as the basis of a prediction that a child is likely to suffer significant harm to be proved to have happened. Every such fact is to be treated as a fact in issue. The majority of the House rejected the analogy with facts which merely form part of the material from which a fact in issue may be inferred, which need not each be proved to have happened. And our submission is that the present case falls into the latter category. The fact in issue is bribery, which must be proved either to have happened or it hasn't happened. But whether there was torture is part of the material from which that fact in issue may be inferred. So Lord Hoffman's statement at paragraph 2 must be read in the context of paragraph 3, and indeed in the context of that case, where, for the reasons given by Lady Hale, the sexual abuse needed to be proved, and if it wasn't proved, it didn't happen. That is also the context in which Lady Hale made the observations at paragraph 32 on which the Court of Appeal relied in the present case. The Court of Appeal relied, it's paragraph 57 of the Court of Appeal judgment at MS 202. But can I take it from Lady Hale's judgment, paragraph 32? Her ladyship said, in our legal system, if a judge finds it more likely than not that something did take place, then it is treated as having taken place. If he finds it more likely than not that it did not take place, then it is treated as not having taken place. He is not allowed to sit on the fence. He has to find for one side or the other. Sometimes the burden of proof will come to his rescue. The party with the burden of showing that something took place will not have satisfied him that it did. But generally speaking, a judge is able to make up his mind where the truth lies without needing to rely upon the burden of proof. Again, Lady Hale is speaking in my submission in relation to facts in issue in the proceedings and not background material which assists the court in deciding whether the fact in issue did or did not take place. Her ladyship would, in my submission, have been surprised to be told that she was there determining that hearsay evidence, or indeed any evidence relevant, but particularly hearsay evidence relevant to deciding a fact in issue, must itself be the subject of a binary determination rather than an assessment of the weight to be given to it in all circumstances. That was not the issue that Baroness Hale was assessing, far less in relation to hearsay evidence. So our submission in the present case, before we come to the specific context of torture, is that it is elementary that where one is dealing with hearsay evidence, which is or may be material to a fact in issue, it's for the court to assess its weight, and the court is certainly not obliged to make a binary finding on matters of hearsay which are or may be relevant to determining the fact in issue in that case. The case turns, in my submission, re-B, on the particular context that whether this man had or had not sexually abused his child was a matter that needed to be determined one way or the other. In any event, we respectfully submit that the approach of the Court of Appeal that the judge had decided torture, and therefore any concern about torture was of no further relevance, cannot stand with the reasoning of the Appellate Committee in relation to torture in the case of A number 2. A number 2 appears in the authorities volume 1, tab 2 at MS 1338, and we've addressed this authority in our written case. We've made detailed submissions in our written case at paragraph 58 and following at MS 105. Now, the starting point in relation to Re-A is that their lordships held, and there's no dispute about this, of course, that there is a prohibition on the admission of evidence which was obtained by torture. If torture is established on the balance of probabilities, the evidence must be excluded. It is inadmissible. All 7 members of the Appellate Committee so held, and we've given the references in paragraph 58 of our written case, MS 105 at 58 subparagraph 1, but it is important to look briefly at the main paragraphs in the speeches, because the argument against us is that the speeches in Re-A focused on the special nature of the Special Immigration Appeals Commission, the SIAC. And we say that the members of the Appellate Committee expressly emphasised to the contrary, that it is the normal common law rules that apply to SIAC, and they apply because they apply to all judicial bodies unless Parliament has expressly excluded these rules, which Parliament had not done. So can I very briefly just remind this court of what was said by the Appellate Committee, all 7 members, on the constitutional importance of the rules relating to evidence produced by torture. Lord Bingham, paragraphs 51 to 52, beginning on MS 1386. MS 1386, paragraph 51, it's 3 lines from the bottom of the page. Lord Bingham notes that the English common law has regarded torture and its fruits with abhorrence for over 500 years. Lord Bingham said that he was, over the page, startled, even a little dismayed at the suggestion and the acceptance by the Court of Appeal majority, Lord Justice Neuberger was in the minority, that this deeply rooted tradition and an international obligation solemnly and explicitly undertaken can be overridden by a statute and a procedural rule which make no mention of torture at all. And then at E, his lordship said that it trivialises the issue before the House to treat it as an argument about the law of evidence. The issue is one of constitutional principle, whether evidence obtained by torturing another human being may lawfully be admitted against a party to proceedings in a British court, irrespective of where, by whom, on whose authority the torture was inflicted. To that question, I would give a very clear negative answer. His lordship emphasises the point at 52, the principles of the common law standing alone compel the exclusion of third-party torture evidence as unreliable, unfair, offensive, incompatible with principles, and he refers to the European Convention and the Torture Convention. Lord Nichols deals with the matter at paragraph 76 on MS 1395, the second sentence of paragraph 76, the ethical ground on which information obtained by torture is not admissible as proof of facts is applicable in these cases as much as in any other judicial proceedings. Lord Hoffman, paragraph 95, which is on MS 1399. Lord Hoffman says at 1399, paragraph 95, in his lordship's opinion, Parliament, in setting up a court to review the question of whether reasonable grounds exist for suspicion or belief, was expecting the court to behave like a court. In the absence of clear express provision to the contrary, that would include the application of the standards of justice which have traditionally characterised the proceedings of English courts. It excludes the use of evidence obtained by torture, whatever may be its source. Lord Hope, at paragraph 114 on MS 1404. MS 1404, paragraph 114, his lordship refers to the rule that the Commission may receive evidence that would not be admissible in a court of law, but I consider, in agreement with all your lordships, that this rule is incompatible with the fundamental nature of the objection to the admission of statements obtained by the use of torture wherever it was administered, and that it does not extend to them. That being the nature of the objection, the question whether it can be overridden, and if so, in what circumstances, must be left to the legislature. This is not a matter that can be left to implication. Nothing short of an express provision will do, to which Parliament has unequivocally committed itself. Lord Roger, to like effect, paragraph 137, which is on MS 1412. MS 1412, Lord Roger, paragraph 137, his lordship says, one comes back to the centuries-old view. Statements obtained by torture are unacceptable. To rely on them is inconsistent with the notion of justice as administered by our courts. And then 2 lines further on, SIAC, of course, is different in many ways, as the relevant legislation and regulations show. Therefore, if there were any sign that Parliament had considered the point when passing the Act that there might be a case for holding that the necessary implication was that SIAC should take account of statements obtained by torture in another country. But that issue does not arise, since Parliament was never asked to consider the question either when passing the Acts or when approving the rules. The point does not appear to have occurred to anyone. In any event, says his lordship, the revulsion against torture is so deeply ingrained in our law that in his lordship's view, a court could receive statements obtained by its use only where this was authorised by express words or perhaps the plainest possible implication in a statute. Here there are no express words, and the provisions approved by Parliament do not go so far as to show that the officious bystander who asked whether SIAC could rely on a statement obtained by torture would have been testily suppressed with an "oh, of course" from the legislature. I therefore hold SIAC should not take account of statements obtained by torture. Two others, Lord Carswell, paragraph 150, which is MS 1416. 1416, paragraph 150, Lord Carswell says his lordship has to conclude in agreement that the duty not to countenance the use of torture by admission of evidence so obtained in judicial proceedings must be regarded as paramount. To allow its admission would shock the conscience, abuse or degrade the proceedings, and involve the state in moral defilement. And finally, Lord Brown of Eton under Hayward, his lordship dealt with the matter at MS 1420, at paragraph 164. His lordship said, in common with the other members of the committee, essentially for the reasons they give, I too would reject the Crown's contention. In question here is not the power of the executive, but the integrity of the judicial process. SIAC is a court of law, indeed a superior court of record, etc., etc. So the starting point is that the reason why evidence obtained by torture is inadmissible is nothing whatsoever to do with the special status or the special rules of SIAC. On the contrary, the general rules and the reasons for them apply to SIAC as they do to any other court in the absence of any parliamentary statement to the contrary, expressly or by necessary implication, of which there was none. That's the starting point. Then there was a division of view in the appellate committee on the question of proof. The majority of the appellate committee, 4 of them, held that the evidence should only be excluded, it was only inadmissible, if the judge or tribunal conclude, on a balance of probabilities, that it was obtained by torture. I don't need to take time reading those passages, but that was the view of Lord Hope at paragraph 118. It was the view of Lord Roger at paragraph 145. It was the view of Lord Carswell at paragraph 158, and it was the view of Lord Brown at paragraph 172. 3 of the 7 members dissented on this point. They took the view that the judge or tribunal should exclude the evidence if there was a real risk that it had been obtained by torture. That was the minority view. A real risk it has been obtained by torture means it's inadmissible. That was the view, the minority view, of Lord Bingham, paragraph 56, Lord Nichols, paragraph 80, and Lord Hoffman, paragraph 98. Importantly, for the purposes of the present case, the majority of the appellate committee, who took the view that the evidence was only inadmissible if proved on a balance of probabilities to be the result of torture, the majority also held that where it cannot be shown on a balance of probabilities that the evidence was obtained by torture, and therefore the evidence is not inadmissible, doubts about whether torture was used should be taken into account as a factor relevant to the weight to be attached to the evidence. That was the majority view. It's not inadmissible, but doubts about torture should be taken into account in assessing the weight to be given to the evidence. And can I draw the court's attention to where the majority took that view? The first judge in the majority was Lord Hope. And Lord Hope deals with this matter on MS 1405 at paragraph 118. Lord Hope at paragraph 118, MS 1405. And it's under the heading, the standard of proof. And Lord Hope says at paragraph 118, Lord Bingham then says that SIAC should refuse to admit the evidence if it's unable to conclude that there is not a real risk that the evidence has been obtained by torture. My own position, for reasons I shall explain more fully in the following paragraphs, is that SIAC should refuse to admit the evidence if it concludes that the evidence was obtained by torture. I am also firmly of the view that if it approaches the issue in this way, it should apply the lower standard of proof. The liberty of the subject dictates this. So SIAC should not admit the evidence if it concludes on a balance of probabilities that it was obtained by torture. And then this, in other words, if SIAC is left in doubt as to whether the evidence was obtained in this way, it should admit it, but it must bear its doubt in mind when it is evaluating the evidence. And that's what we rely upon. And that is precisely what the Court of Appeal in the present case, applying its binary approach, deprecated, and in my submission, wrongly deprecated. The Lord Hope continued at paragraph 122. Most of this concerns why Lord Hope did not agree with Lord Bingham, and I won't trouble the court with that, although the court will no doubt want to read it. But at paragraph 122 on MS 1407, Lord Hope says support for this approach is to be found in a decision in the case of Inri El Motadezek in the German court in Hamburg in 2005. And this was a criminal court. The defendant had been charged, as we're told, with conspiracy to cause the 9/11 attacks. And at the end of paragraph 122, Lord Hope notes that there was enough in that case to raise the suspicion that torture had been used. There was a question to answer on this point. And then the German court addressed that question. And the German court found, on the whole, the division does not consider the use of torture within the meaning of Article 1 of the Convention as proved. So there was a finding by the German court that torture had not been proved. And over the page, MS 1408, just under letter C, this is page 291 of the report, MS 1408 at letter C, Lord Hope says in a concluding paragraph, the court said that it was mindful of the problems posed by the possible use of torture and would take this into consideration when assessing the information in the summaries. The summaries were the, as we see from the first line on that page, the summaries of the examinations of the defendant. Would take this into consideration when assessing the information in the summaries. And they added this does not imply legitimization of the use of torture, even in view of the enormous scale of the attacks. So what Lord Hope is saying, he says expressly at paragraph 118, even when torture is not proved on a balance of probabilities, you take any doubts about torture into account when evaluating the evidence, and he cites the German courts as supportive of that approach. The second judge in the majority was Lord Roger, who adopts the same approach as this court can see at MS 1413. At paragraph 140, at the beginning of paragraph 140, Lord Roger says that as Lord Hope has explained, the Hamburg court adopted a somewhat similar approach in the case before them. The somewhat similar approach was they looked to see whether or not the evidence had been produced by torture. Was it proved on a balance of probabilities? And at the top of MS 1414, the next page, Lord Roger notes in the first three lines of MS 1414 that the court, that's the German court, concluded that it had not been proved that torture had been used in the examination of the three witnesses, especially having regard to certain exculpatory elements in their statements. So torture wasn't proved in the German case. And Lord Roger then goes on to explain in paragraph 141, just under letter B, Lord Roger says, if substantial doubts remained, the possible violation, that's of the principle no torture, had not been proved and the relevant statement could be used. The court therefore took the view that it was their duty to consider the summaries so as to investigate the facts of the case as fully as possible, but they would take the allegations into account in evaluating the evidence. So again, Lord Roger is making it very clear that where torture is not proven on a balance of probabilities, the allegation that there was torture, the doubts about it, are to be taken into account by a court in assessing the weight of the evidence. And Lord Roger adds at 142 in the opening sentence, in my view, the same factors as weighed with the Hamburg court should weigh with the House. And Lord Roger repeats his point, his lordship's point, at 145 at the bottom of MS 1414. Lord Roger says, when everything possible has been done, it may turn out that the matter is left in doubt, and that using their expertise, SIAC cannot be satisfied on the balance of probabilities that the statement in question has been obtained by torture. If so, in my view, SIAC can look at the statement, but should bear its doubtful origins in mind when evaluating it. And that's our submission. The third Lord of Appeal in the majority was Lord Carswell, and on this point, Lord Carswell speaks at MS 1419 at paragraph 158. And Lord Carswell says that after initially favouring the Bingham test, in other words, any real doubt and the evidence is to be excluded, I have been persuaded that the Hope test should be adopted by SIAC in determining whether statements should be admitted when it is claimed that they may have been obtained by the use of torture. So he's agreeing with Lord Hope, and he adds, Lord Carswell adds at the end of that paragraph 158, while I fully appreciate the force of the considerations advanced by Lord Bingham, that's for the majority, for the minority, I feel compelled to agree with Lord Hope's view in paragraph 118 that the test which he proposes would, as well as involving fewer practical problems, strike a better balance in the way he there sets out. And I've read to your lordship's paragraph 118, MS 1405, and the balance that Lord Hope there adopts is that the inadmissibility point depends on proof on the balance of probabilities, but any doubts must be taken into account when evaluating the evidence. And that's what Lord Carswell is agreeing with. So that's 3 judges in the majority. The 4th judge in the majority on this point was Lord Brown, and Lord Brown expresses agreement with Lord Hope and Lord Roger at paragraph 173 on MS 1423. MS 1423, paragraph 173, his lordship expresses the difficulty that he has with the real risk test espoused by certain of your lordships. In other words, a real risk is sufficient to render the evidence inadmissible. And his lordship says at the end of the paragraph that he prefers the test favoured by Lord Hope and Lord Roger. He doesn't say that he dissociates himself from what they say on taking doubts into account in assessing the evidence. Of course, that's the 4 judges in the majority. Of course, the minority did not address this point because the minority, Lords Bingham, Nichols, Hoffman, took the view that if there's real doubt, the evidence is simply inadmissible. And we say that is a very clear judgment by the majority. The minority would have gone even further, but the majority is the governing law. How then did the Court of Appeal in our case seek to distinguish this authority? And we see that in the Court of Appeal's judgment in the present case at MS 202. At paragraph 60, paragraph 60 states, we prefer, this is MS 202, we prefer the submissions of Mr. Smuhar for HNA on this issue. We agree with him that the context of REA number 2 is entirely different from that of the present case for the reasons he gave. So we need to go back to paragraph 58 on the left-hand side of MS 202 to see what submissions Mr. Smuhar made, which the Court of Appeal was accepting. And paragraph 58 says, Mr. Smuhar submitted that Re B, that's the child welfare case that I've dealt with, should be followed in this case because it's in line with established principles of the law of evidence. And I've made my submissions on why it's not, at least Mr. Smuhar's submissions are not in line with the laws of evidence. And then, whilst the unique context, and I invite your lordships to note those words, the unique context of Re number 2 meant that it had no application in the present case. Re number 2 concerned a statutory tribunal, the task of which was to assess whether there were reasonable grounds for belief in the existence of a risk. That was very different to the task that faces a civil court, which is to determine whether a claim succeeds or fails based on findings of fact. Further, SIAC was subject to its own evidential rules and procedures, including that it could receive evidence which would not be admissible in a court of law. See Lord Bingham. There was no hint in the judgments that the principles they articulated had any application outside SIAC. Well, we respond with great respect that this narrow interpretation of the principles stated by the Appellate Committee in Re A number 2 is unsustainable. It's unsustainable because all 7 members of the Appellate Committee, and I've just shown the court the relevant passages, all 7 members of the Appellate Committee, the majority as well as the minority, emphasised that the rules they were articulating, the principles they were articulating, arose from the common law repugnance for torture. None of the 7 members of the Appellate Committee focused on the specific function of SIAC, or indeed the specific statutory provisions which applied to it. On the contrary, the approach taken by the Court of Appeal that SIAC is special, SIAC is different, is precisely the argument that the Secretary of State unsuccessfully advanced in A number 2. SIAC is special. It has a special statutory function. It has special rules that apply to it. And that argument failed, and the reason it failed, see the passages I've shown this court, is because the common law is hostile to evidence which is or may have been adduced by torture, and therefore any court, any tribunal exercising a judicial function is obliged to follow the principles laid down in A number 2, subject only to an express statutory provision to the contrary, or possibly an implication from special statutory provisions, of which, said all 7 members of the Appellate Committee, there was none in the SIAC case. So the suggestion that SIAC was special and distinct made by the Court of Appeal, in my submission, is quite unsustainable. Indeed, the reasoning of the Court of Appeal places the reasoning of the Appellate Committee on its head and attributes the decision in Re A number 2 to precisely those factors which were unsuccessfully relied upon by the Secretary of State as a justification for special rules in the SIAC context, an argument expressly rejected by the Appellate Committee. Indeed, I would add that the fact that the Appellate Committee was not deciding any of these principles by reference to the specific statutory functions or special statutory provisions of SIAC is also apparent from the majority's reliance on the decision of the Hamburg Court on the very issue with which this court is today concerned. And as I've shown, this court, in holding that in weighing the evidence which has not been proved to be produced by torture, but which may have been produced by torture, doubts about whether there was torture must be taken into account, was a conclusion reached by Lords Hope and Lord Roger, with whom Lords Carswell and Brown agreed, specifically by reference to the decision of the Hamburg Court in a criminal case. Nothing to do with the specific context of SIAC. So we respectfully submit that what the Court of Appeal said at paragraph 60 cannot be sustained. There are further points to make on this, which I will, if I may, leave to Mr. Jaffe, because he's pointed out in his written case for liberty, MS 182, paragraphs 23.5 and 23.6, that the Court of Appeal was in any event misguided in its description of the role and the jurisdiction of SIAC. If it matters, they didn't get that right, and I respectfully adopt what Mr. Jaffe has explained, and he may want to address that. If he doesn't, I rely on his written case. I also draw attention to what the Court of Appeal said at paragraph 60 of the Court of Appeal judgment. It's MS 202, and the Court of Appeal at paragraph 60 in lines 8 to 10, they say, or maybe 9 to 11, they say, this is on the right-hand column of MS 202, paragraph 60, roundabout line 9 or 10. They say, whilst we fully accept and endorse the constitutional abhorrence for torture, we do not consider it bears on a civil judge's responsibility to decide whether something is more likely than not to have happened. Well, in our submission, the approach adopted by the Court of Appeal substantially undermines the constitutional principle endorsed by the Appellate Committee in A number 2. And the reason why it undermines the constitutional abhorrence for torture is because if the Court of Appeal were correct in the present case, it would mean that other than in the context of a SIAC determination, because SIAC is different, other than SIAC, notwithstanding the enormous practical difficulties in proving that torture occurred, judicial doubts about whether there has been torture must be ignored in assessing the weight to be given to evidence, particularly hearsay evidence. Proof of torture is difficult, and it's difficult for the reasons given by liberty in their written case at paragraphs 25 to 35, it's MS 183, which we adopt. Torturers do not readily admit their trade, which usually takes place in detention without publicity or oversight. And if, as the majority of the appellate committee held, and is the law, evidence is only excluded, it's only inadmissible, where it can be proved on a balance of probabilities to be derived from torture, then the constitutional abhorrence of torture requires, as the majority held, that doubts about torture must be taken into account by the court or tribunal in assessing hearsay evidence that may have been obtained in such an objectionable manner. So we submit that even if our earlier submissions on the general law of evidence are not well founded, and we rely upon them, there are special rules that apply where evidence is said to have been obtained by the use of torture, and even where it cannot be proved on a balance of probabilities that the evidence was produced by torture and therefore it is inadmissible, the court must assess the risks that there was torture when weighing the strength, the value of that evidence in any particular case. And therefore, if we're wrong on issue 1, and if this case is to be remitted, the new judge must ask himself or herself whether or not, at the very least, whether or not there was a risk that this evidence, confession evidence, was produced by torture, and if so, weigh that in the balance in deciding what weight to give to the admission evidence. I say that what the appellate committee said in REA number 2 is in any event not inconsistent with the general rules of evidence. It's a particular application. Yes, my lord.
I'm still muted. It might be said that there's an inconsistency in the Court of Appeal's approach, because they accepted, as I understand it, that the exclusionary rule does apply in civil proceedings, that if it's more likely than not that there was torture, the evidence is inadmissible. The reason for that, as the House of Lords explained, is the constitutional abhorrence of torture. And it might therefore be thought to follow that that must be relevant in ordinary civil proceedings. Well, on the Court of Appeal's own approach, once you accept the exclusionary rule applies.
I respectfully agree, and there's no dispute the exclusionary rule applies, no dispute by the Court of Appeal, no dispute by my friends. I very respectfully submit that the approach taken by the Court of Appeal is unsustainable. It's misguided on any number of levels. It's misguided for the reason your lordship gives. It's misguided because they thought wrongly that Re B is applicable, and they thought wrongly that Re A number 2 is a case confined to the context of SIAC. That's our case on the second issue. We say, yes, I'm sorry, my Lord Burrows has a question.
Lord Briggs was before me, sorry.
Sorry.
I think Lord Briggs was before me.
Okay.
Well, I've been unmuted, so I'll go first. Lord Panic, you said when dealing with Re B that the key point to understand is that the all or nothing rule, as you describe it, there applied, only applies to facts in issue. And it's, I think, implicit in your submissions that the question whether or not there was torture in this case was not a fact in issue. By what yardstick do you suggest that the court generally works out whether a particular fact to which evidence is addressed in a case is or isn't a fact in issue?
Your Lordship asked a very difficult question, which is not answered by Lord Hoffman in Re B. His Lordship assumes that there is a distinction. Cases go on one side or the other. And I've sought to explain my submission to your Lordships as to why the issue of sexual abuse in Re B fell on the fact in issue side of the line, the statutory context. I am unable to articulate for your Lordship a rule which will be applicable in all circumstances as to which side of the line a particular case does or does not fall. I confine myself to the submission that in this case, the question of whether there was or was not torture is not the fact in issue in the proceedings. The fact in issue is whether or not there was bribery. Indeed, torture is a third level question. The primary question is whether there was bribery. Relevant to that issue as a second level question is the admissions, because the admissions were evidence which was said by HNA, understandably said by HNA, to go to the fact in issue. Was there a bribe? Why? Well, your people admitted it. The question of torture is a level down, because the question of torture came in to the case as evidence which was said by us to undermine the strength, the weight to be placed on the admissions. So for those reasons, I would say that the question of torture falls in this case on the wrong side of the line. It's also relevant, I would suggest, to that question that the issue of torture arises in the context of the weights to be attributed to the admissions, which are in fact hearsay evidence, and we therefore have the value of Section 4, Parliament's direction as to how one looks at such material. And Parliament, in my submission, makes it very clear indeed that such issues are not to be determined on a binary basis. That's my answer to my Lord's question.
Lord
Thank you.
That was my exact question. But I was therefore just wondering whether Lord Panic, although he's already, I think, indicated that he doesn't wish to give any grand theory as to what is a fact in issue and what isn't, could one say that questions that go to the reliability of evidence are always going to be background material and not facts in issue?
I'm grateful to your Lordship. I would certainly submit that those circumstances make it inherently unlikely to be a case where they are facts in issues. I'm a cautious advocate, and I'm reluctant to suggest to this court that it should lay down an absolute rule that applies in every case, because we all know that in exceptional circumstances there may be some exception. And therefore, I hope I don't need to go further than suggesting that those circumstances which my Lord emphasises and the circumstances which I had referred to make it exceptionally unlikely that it's going to be a case where it is a fact in issue. And that is certainly true here. My Lord Brooks had another question.
I mean, we can all remember from our days at the bar the principle that if you were stopped cross-examination by a judge and asked why you were asking a question, and you said, well, it goes to credit, then of course you were landed with whatever answer you got. And I wonder if there may be some analogy, but a question which goes to credit maybe an inquiry about a fact about the witness, which, if proved, would reduce the weight of his testimony.
Well, I see the force of that, my lord, yes. Again, it's a factor that makes it exceptionally unlikely that this would be a fact in issue. But I'm conscious that we have re B, where the answer given to what was a fact in issue vitally depended upon the statutory context in which the issue arose. And that's another reason why I'm very reluctant to articulate an absolute rule that would apply in all circumstances.
Yeah.
That's my position. The court will say if it thinks it's appropriate to articulate a general rule. Those are the matters, subject of course to any questions, those are the matters that I wanted to draw attention to on the second issue, and it's why I say if we're wrong on the first issue, and if your lordships decide that the Court of Appeal was correct to remit the case, it should be remitted on the basis both that it's for the new judge to decide whether there was or there was not torture on a balance of probabilities, because your lordships would have decided, taking HNA's case at its highest, that Mr. Justice Knowles made errors of approach and analysis in relation to torture. And in my submission, his errors should not prevent a proper analysis at a rehearing. And also, and in any event, if there is to be a remission, it must be open to the new judge to assess what risk there is that the admissions were the result of torture, and to take that into account in deciding on the weight to give to the admissions evidence. That's our case. There's a final issue, as I mentioned, on the appeal, which was the matter or various matters relating to irrebuttable presumptions in relation to bribery. We're not pursuing that matter, and it's for the reasons set out in our letter to HNA's solicitors. The letter appears at supplementary MS. I hope the court has this supplementary MS bundle. It's called supplementary documents, and supplementary MS page 4 and 5 deals with this issue. May I ask if the court has access to that document? I hope that the lordships do. At supplementary MS page number 4, in the middle of the page, your lordships see that we're here addressing what was issue 7 in the agreed statement of facts and issues. And that issue was whether the Court of Appeal erred in law in finding that a payment made to an individual who was not an employee or agent of GCS, they were the charterer, should be irrebuttably presumed to have induced GCS to enter into the charter party. And we note at paragraph 8 that HNA in their written case had given a number of reasons why this issue does not need to be argued before this court, and indeed why it would be inappropriate to argue the issue. And we've set out at paragraph 9, I won't read them out, the points that were made by HNA. And we say at paragraph 10 that we've carefully considered what they say, and we agree that much more appropriate is that all the issues arising under this head can and should be left for argument and determination on the facts to be found at any retrial, if there is a retrial, and therefore we're not pursuing the argument. And we reserve our position at paragraph 11 because there may be an issue, depending on how this court decides this appeal, there may be an issue on costs relating to that point, which I certainly don't want to argue now. And I hope it's acceptable to your lordships that we deal with that parts or potential parts of the case in that way.
I don't think you're facing any resistance, Lord Panic.
Thank you. Thank you very much, my lord. Subject to any questions, I've taken 30 minutes less than advertised. I hope that's a merit rather than a defect. And subject to questions, that's what I want to say on behalf of the appellant on this appeal.
I don't see any of my colleagues wishing to question you, and certainly I'm not going to criticise you for saving half an hour. Thank you very much.
Thank you, my lord.
Mr. Jaffe, it falls to you to make the submissions on behalf of the intervener's Liberty. Thank you.
My lords, Liberty's submissions deal only with the issue of, which is how a judge should approach hearsay evidence that may have been obtained by torture. As the court knows, the dispute that's before it is considerably wider. There are disputes about whether the judge, or what the judge in fact decided in this case, whether the Court of Appeal analysed the judge's decision correctly, and whether the issue of principle even arises at all. Those, of course, are all questions for the parties, and Liberty makes no comment on them. What I do propose to do is to deal with 4 points. First of all, to summarise what Liberty says is the proper approach to that question of principle. Secondly, to identify some of the consequences of the Court of Appeal's approach. Thirdly, to deal with the points that have just been raised by Lord Briggs and Lord Burrows about the proper approach in Re B and a fact in issue. And then finally, the attempt which was made by the Court of Appeal to distinguish A number 2, or perhaps confine it to its facts and cases in SIAC. Just before I turn to those, I mean, by way of introduction, one doesn't really envy the task of the trial judge in this case, because he was confronted with the question of having to decide whether there'd been a bribe or not without the benefit of oral evidence from the payer or the recipient, limited contemporaneous documentation. He did, of course, have the quite detailed written confessions, which were later retracted, but they are, of course, at least to a British lawyer's eyes, quite curious documents. Without turning it up, when one reads them, and I'm just reading from MS 1124, having been educated by the police officers, I've now realised the mistakes which I've made. Now I'm willing to truthfully confess for leniency, and I would like to give my appreciation to the Public Security Bureau for its lawful acts and protection of my rights, and so on and so on. The context is, of course, a system of criminal justice which is very different from our own, and in which confessions are prized as being the best evidence which can be obtained, which are near universally deployed, and where acquittal following a criminal trial is vanishingly rare, and which occurs in a country in which torture is hopefully declining, but undoubtedly is still used, and where under a party system, the commercial interests of very large companies of national importance, the police and the security forces, the judiciary and the executive may not be easily or readily distinguishable in a way which we would understand. Now that's a relatively unusual but not unheard of set of issues in a commercial case. But of course, those types of issues are the daily diet of the administrative court and of SIAC in national security investigation. And that's the purpose of Liberty's intervention, because of the potential knock-on consequences of the analysis of the Court of Appeal in this case. The way that these types of issues normally come before the courts is that someone will be subjected to some kind of civil legal measure, such as a TPIM, the Terrorism Prevention and Investigation Measure, the modern version of a control order. He will normally be given a limited gist of the basis for the measure. You travel to Ruritania to attend a terrorist training camp, something like that. It won't disclose the source. The source will be disclosed to the administrative court in closed, and the source, for example, might be a prisoner in Ruritania who's produced a denunciation of this person under interrogation. Now, the UK intelligence services have, of course, been assured that the Ruritanian prisoner is being treated entirely properly and humanely, but everyone equally knows that the authorities in that country have a well-deserved reputation for brutality. little is actually known about the prisoner's conditions of detention. What the administrative court then have to do is they then have to assess whether the evidence is torture evidence, applying A number 2, and if they decide on the balance of probabilities it's not, they then have to decide what weight to give to it. So that's the task set to the lower courts in A number 2. Now, these issues do arise in practice. Now, they normally only arise in closed, and you never read about them in open judgments. There is one open judgment of which I'm aware where these type of issues were mentioned. It's not in the bundles, but it's a recent decision of the Court of Appeal in a case called Kamoka. And the reason that some of the issues were dealt with in open was because the detainee in a foreign country who was allegedly providing the evidence was Mr. Belhaj, who's well known to this court because he's led to 2 appeals to this court in recent years. And the allegation was that some of the denunciations against Mr. Kamoka and others derived from evidence which he had given in Libya. So that's the context in which these issues will come up again. So what's the proper approach? Well, I've already indicated that admissibility is governed by the test in A number 2. Was torture used on the balance of probabilities? If torture can be shown to have happened on the balance of probabilities, the evidence is inadmissible for understandable constitutional reasons. On the other hand, if on the balance of probabilities torture didn't happen, then the evidence is admissible. And the duty of the court is then to apply Section 4 of the Civil Evidence Act and decide what weight, if any, to give to the statements when making findings of primary fact. And the court's already been taken through today, the judgments of Lord Hope, Lord Roger, and Lord Carswell in A number 2, making that point. Now, it is also common ground, at least as Liberty understand it, that that is an assessment of estimation and weight. Those are the words which are used in Section 4 of the Civil Evidence Act. And that will involve an analysis by the judge of many factors and elements, considering the circumstances, the context, the reality of the inherent probabilities of the situation, and any other contemporaneous material before the court. And importantly, those questions of weight do not then have to lead to a binary answer. Indeed, often they will not permit of a binary yes-no answer. It's an assessment of weight. Now, what the Court of Appeal did in this case is to say that the mere fact that an allegation of torture had been made ought to fundamentally change this approach. Now, if we accept the Court of Appeal's approach, there are then 2 scenarios. The first scenario which applies is that if torture is more likely than not, if it's proven on the balance of probabilities, then the confession goes out, it's inadmissible. Now, that outcome is entirely compatible with the Civil Evidence Act. And that's because of Section 14 of the Act, which says that nothing affects the exclusion of evidence on grounds other than that it's hearsay. So it preserves existing common law grounds for refusing to admit evidence. But there's a second scenario, which is that if torture is not proven on the balance of probabilities, the Court of Appeal say that the court has then finally determined that no torture occurred, and the Section 4 weighing exercise must proceed on the basis that no torture occurred. Now, the practical consequences of that are obviously very significant. They mean that logically, when conducting the weighing exercise, the judge must treat any allegation which is being made that torture happened as being untrue, in effect as a lie. And that will, of course, have great consequences for the assessment of the hearsay evidence as a whole. So the effect of what the Court of Appeal decided is to put a thumb firmly on the scale of the weighing exercise under Section 4 of the Civil Evidence Act. Now that's one strange result. There are other very strange results of the Court of Appeal's analysis. Let's change the facts of this case slightly and assume that the alleged mistreatment didn't involve, for example, waterboarding, and it didn't reach the gravity and severity of torture, but was instead mere, and I say mere in inverted commas, inhuman and degrading treatment. So let's say that Mr. Zhu had been kept in poor prison conditions, perhaps slapped in the face a few times and threatened. No allegation of torture, but still sufficiently serious ill treatment to overbear his free will and extract a confession from him. Well, what happens then? Well, if the Court of Appeal are correct, the exclusionary rule, of course, has no relevance or application. There's no allegation of torture being made. There'll be no basis for finding torture. And so the evidence is admissible. The court would then carry out the Section 4 weighing exercise on a conventional basis. And when doing that, the court would consider the circumstances in which the confession was obtained and the possibility of a risk of mistreatment leading to a false confession. The court, putting it another way, will consider the uncertainty of whether there was in fact mistreatment as going to weight. The practical effect of the Court of Appeal's approach is that when the most serious form of mistreatment is alleged, torture, the court is suddenly required to adopt a different approach, a binary approach of either excluding it or proceeding on the basis that it did not happen. But when the alleged mistreatment is less serious, the court is allowed, on the Court of Appeal's approach, to take into account in a balanced assessment of weight, what weight to give to the hearsay admissions. No requirement exists to make a binary determination. So the more serious the allegation of wrongdoing, the less effect is given to the legislative scheme in the Civil Evidence Act, which is designed to require weighing rather than a binary determination. Now that's troubling in the context of torture, because torture is hard to prove, and usually there's no direct evidence of it because it occurs in detention, which is inadequately controlled. And that's also why in practice, outright exclusion of torture evidence under the exclusionary rule is relatively uncommon because of the problem of proof. Torturers don't boast of their trade. So what should a well-advised litigant do in light of the Court of Appeal's decision? Well, probably to say that mistreatment occurred, never to accept, still less to plead, the T word, torture. Because the last thing you want is to have put in the position where you have quite a difficult mountain to climb, evidentially, of proving torture on the balance of probabilities on the basis of mere hearsay evidence. And then when you're unsuccessful about that, the judge is indeed allowed to take into account the obvious and serious doubts about the circumstances in which the evidence is obtained. Now, that's a consequence which Liberty submits has no textual basis in the Civil Evidence Act. And one thing the Court of Appeal didn't do was to explain how its outcome was to be accommodated within the wording of the legislation. It certainly doesn't achieve the Law Commission's aim of reforming the hearsay rule, so it reflects much more closely how reasonable people evaluate hearsay evidence in the round. And as Lord Panic has already developed, it's also the opposite of what the Appellate Committee said in A number 2. So the question then arises of whether or not Re B provides support for the Court of Appeal's approach. And the way it's put by my learned friend representing HNA is that it is not logically coherent to decide whether or not torture happened on the balance of probabilities in a binary yes-no way for the purpose of deciding admissibility, but then to permit weight to be given to the possibility of torture when deciding the substantive issue of whether a bribe is paid. It says that's impermissible, and it's Re B that prohibits it. Well, the short answer to that in our submission is that that's exactly what Section 4 of the Civil Evidence Act requires in relation to hearsay evidence. And it's not what Re B was considering or deciding. Re B is, of course, not a case about the admissibility of evidence. And the lex specialis on this issue, particularly in the context of torture evidence, is A number 2. But as a matter of principle, one can ask the question of why is that? Well, the answer in Liberty's submission is that there is quite an important distinction between a court making a decision on admissibility of evidence and a court making a decision on a fact in issue when dealing with the substantive issues in the case. Now, in order to unpack that a little bit, a judge sitting in a civil trial has two roles, and they're the roles that would respectively traditionally be performed by a judge and a jury. First of all, the judge sits as the legal umpire in the case, deciding, for example, on the admissibility of evidence. Now, in civil trials, admissibility of evidence doesn't normally raise hugely complicated issues, certainly after the 1995 Civil Evidence Act. But they do still arise, for example, in the case of torture evidence. So that's the judge's job. And in any civil claim that's heard without a jury, the judge is also the finder of fact as well. Now, those roles are distinct, and it's important to analyse what the judge is doing at each stage by reference to those different roles. Because if this case had been heard with a jury, what would have happened in this case is there would have been a voir dire, and the judge, in the absence of the jury, would have decided whether the evidence was admissible, applying A number 2. Now, the judge will have decided either that the evidence is inadmissible, in which case the jury would have never seen or heard of it, in the case probably would have collapsed, or the judge would have decided it was admissible, in which case it would have been put before the jury, at which point the role of the jury is to apply Section 4 of the Civil Evidence Act and to decide what weight, if any, it having been declared admissible, to give to it. And the judge, of course, because this is a commercial court trial heard by a judge alone, as almost all cases are these days, is doing both tasks. But there is an important and principled distinction between them, because sometimes it is necessary to consider factual issues for the purposes of a determination of admissibility. But that does not necessarily bind the judge when applying a different test, and here it's a statutory test in Section 4 of the Civil Evidence Act, when deciding on the substantive issues. And so that's what Liberty would say in response. Sorry, my Lord Legate has a question.
Elaborate, just to elaborate a bit, sorry, just to elaborate a bit further on your point, Mr. Jaffe. It's not very common these days to have a voir dire in a criminal trial to establish whether a confession was voluntary, but you can have one. And the fact that the judge decides that the confession is voluntary and admissible doesn't prevent the jury from taking exactly the same evidence of the defendant and others into account in deciding what weight to give to the confession.
Yes, precisely. And that's simply, I'm simply making that point in order to identify that there is a principal difference between what the judge is doing at the admissibility stage and what the judge is doing making substantive findings of fact. And indeed, the legal test for admissibility may well be different from the legal test for making findings of fact. And that's, of course, the case here. The legal test for admissibility is whether or not it's torture on the balance of probabilities. The legal test on the substantive issue is properly to be analysed by reference to Section 4 of the Civil Evidence Act.
Going back to Lord Panic's point, or his unwillingness to have a general rule about what is a fact in issue, making this distinction between the legal umpire role and the fact-finding role of a judge, are you suggesting that a fact in issue for the purposes of admissibility is not to be treated as a fact in issue for the purpose of the substantive decision?
Well, I would put it slightly differently, that a fact in issue for the purpose of the substantive case before the court does not include any questions of fact that a judge may need to consider on an admissibility, making an admissibility decision. I think that's probably the same point as my Lord was putting to me, but I just put it the other way around.
Yeah, thank you.
I'm also slightly reluctant to give your lordships a formulation that I would invite the court to put in a judgment for all time as to what a fact in issue is, but defining it like a silhouette by its absence, it should not include a decision which is made by a judge on the question of admissibility, particularly where a different legal test applies at the respective stages.
Thank you.
Can I turn then and deal briefly with whether this is a special principle, or A number 2 is identifying special principles which apply in SIAC alone. My learned friend acting for HNA identifies 6 reasons. why the position in SIAC is different, and so A number 2 does not provide a proper guide to the correct approach. First of all, they say that liberty is at stake. Sometimes that is certainly true in SIAC, but in many cases it is not. The most common case which is heard in SIAC is a refused naturalisation application for someone who already holds indefinite leave to remain. So the most common issue that one sees in the records of SIAC's decisions are whether someone should become British, not, for example, whether they get to stay here or their liberty. SIAC deals with many cases that do not involve liberty. There's, of course, no hint in A number 2 that that is a requirement for the application of its approach. Secondly, it said that national security is at stake in SIAC. Well, of course, that's quite right. But the special national security context was rejected as the reason for a different approach in A number 2. And of course, national security issues regularly arise in ordinary litigation too. Thirdly, it said that there is an inequality of arms between the parties in SIAC. Well, that's undoubtedly true, but it's difficult to see why that should lead to a different approach to the law of evidence, especially if it would lead to a different approach to the law of evidence against the party who is alleging that torture evidence is being relied on against it. There's no principal basis for that conclusion. The fourth point which is taken is that SIAC considers intelligence material and has special advocates and closed material proceedings. Well, that of course makes no difference to the admissibility of evidence. It may mean that the arguments on admissibility are taken in closed by the special advocates. That's what would happen in my hypothetical example that I gave at the outset of my submissions. But of course, such issues arising in ordinary civil litigation are now relatively routine after the Justice and Security Act 2013. One has the same special procedures in civil trials as well as in SIAC. Fifthly, it said that SIAC's approach is inquisitorial, not adversarial. That might come as a surprise to those who've litigated in SIAC. SIAC, as a matter of law, is not an inquisitorial jurisdiction. SIAC, by statute, simply takes over the appellate jurisdiction of the first tier tribunal in any case where the Secretary of State has issued a certificate that the decision was taken at least in part on national security grounds. So it's no more or no less inquisitorial than in any other immigration case. SIAC also has a separate jurisdiction, which we set out in our written case, of effectively hearing judicial reviews against a refusal of a decision by the Secretary of State to grant naturalisation. And those decisions are decided on traditional judicial review grounds. So again, not an adversarial jurisdiction. And then finally, it said, well, SIAC is concerned with making a prospective assessment of risk. Well, sometimes, of course, that's true. SIAC, for example, might deal with a straightforward asylum claim with national security implications about whether someone would be at risk if they were returned to a particular country. But often it's just hearing ordinary immigration appeals where there are national security issues. And the role of the tribunal, or SIAC in a case where the case is allocated to SIAC, is simply to determine for itself the relevant facts and then apply the law to it. And that was recently confirmed by this court in the case of MS Pakistan, where the court confirmed its long line of authority that the role of an immigration tribunal is simply to conduct a traditional trial, find the facts, and to apply them to the law. Then finally, my lords, we have all been so far assuming that the dicta of Lord Hope, Lord Roger, and Lord Carswell in A number 2 stand alone. They were the only authority on this issue which Lord Panic was able to show you. Liberty suspects that it would be surprising if in the last 15 or so years, A number 2 had not been applied either inside or outside of SIAC since it was decided. Now, Liberty has no knowledge whether there are in fact such decisions, but it seems at least possible that there are. And that's because these issues are very likely to have been handled in closed hearings and with closed judgments. Now, this court is, of course, the Supreme Court, and it would not be bound by any such consideration or any such decision. But in a common law system, the work of an apex court benefits from seeing and understanding the work of judges at lower levels in the court system, because reasoning is built up from precedent. Now, if the court in this case considers that it would benefit from seeing whether the test in A number 2 that's being said by HNA to be of limited application, and indeed by the Court of Appeal to be of limited application, does in fact work in practice, and how in practice it's been applied, the court is entitled to see and ask for a search of the so-called Library of Closed Judgments, which is kept in the Royal Courts of Justice. And arrangements have been published in a practice direction, which is in the authorities at MS 3192, for such searches to be requested by judges, so that the court can see how A number 2 has in practice been applied. As I've said, though, we simply don't know whether there is such authority, but it does seem likely, given the type of issues which arise in cases in SIAC and the administrative court, that the type of issues which this court is now considering on the basis of quite limited authority, apart from A number 2, probably have been in practice considered in some detail before. My Lord, unless I can assist the court any further, those are Liberty's submissions. And I should also add that Liberty is very grateful to the court for granting permission to intervene, and also for giving this opportunity to make some oral submissions as well.
Mr. Jeffrey, the court is grateful to you for your submissions. Thank you. Now, Mr. Brown, do you wish to commence your submissions at this stage?
My Lord, I'm in the court's hands. The issues have been substantially narrowed over the course of the oral submissions today, so we are under no pressure of time whatsoever. I can start and comfortably finish our submissions over the course of tomorrow by starting tomorrow, or I can spend 30 minutes introducing the submissions now. So as the court prefers.
I think I would prefer that you give us an outline of where you're going and use the half hour that we have available.
Yes. So I propose to address the respondent's case as follows. So first of all, we will address the crucial issue in the appeal. So was the judge's treatment of the admissions evidence adequate in the circumstances of this case? And we say that the simple and central flaw in the judgment was the inadequate treatment of the admissions of bribery. That's a bribery that was perpetrated against HNA by two of Shagang's employees, Mr. Zhu and Mr. Shen, and the recipient of the bribe, Mr. Jia T, who, as the court will appreciate, was an employee of another group company and was a college friend of Mr. Zhu, and the son of Mr. Jia H, who was a general manager and chairman within GCS and HNA. And in that context, we will address Shagang's concerns, as addressed this morning, about the Court of Appeal's criticisms of the judge's reliance on the following matters. First of all, the fact that the PSB officer's account had not been tested with them in China. So paragraph 90 of the judgment, but see also paragraph 105 of the judgment at MS 226, which considers that point by reference to the torture issue. And I'll also address the possibility that a false confession or false confessions may have been made for leniency. That's the first area. The second area is the issue of whether inadequate judicial reasoning is a sufficient basis for allowing an appeal. So we say that this case is a category of cases which is exemplified, a category of errors which is exemplified by cases such as Assicurazioni and Datec, and it does not depend on challenges to the underlying facts, as opposed to the adequacy or cogency of the reasoning underlying those conclusions. There was today in Shagang's submissions a tantalising reference to Datec, as there is in their written case, but no development of that on the part of Shagang as to why the Court of Appeal was wrong to say that on application of the reasoning exemplified by Datec, the judge here fell into error. Now, we say that those issues fundamentally determine the appeal, and the remaining issues as to whether the judge erred in taking into account residual doubts about torture is fundamentally academic. However, we will address the further issues in respect of the fresh evidence and the specific order for remission that the Court of Appeal made. And we will address the specific issue of whether the Court of Appeal was wrong to say that the judge had found torture not to have been proven. Finally, we'll address the issues which are now cast by Shagang as being issue 2 in the appeal in relation to the scope of the retrial and whether specifically torture should be included within the scope of the retrial. And in that respect, we will address the points about what are properly described as facts in issue in civil litigation, and whether the principles expressed in A number 2 are sensibly to have any application outside the specific context of national security cases. Is it right that an ordinary civil judge, for want of a better expression, is required to apply the A number 2 approach in an ordinary commercial dispute? So, my lord, that's the overview as we see it. I'll begin then with the crucial issue. And we say that there was ultimately a single issue for the Court of Appeal. And that single issue was the judge's judgment wrong on application of CPR Rule 52.21(3)A, which is at supplementary NS 19. We'll look at this provision in slightly more detail in the context of DATEC. If I can ask the court please to note the following, which will be familiar to the court. The exercise is one of review of the decision. That's a wide concept and includes review of the process of decision making, not only the outcome. So it is our case that it is part of the appellate function of the Court of Appeal to ensure an irreducible minimum standard of analysis below which a trial judge cannot go. Fresh evidence is dealt with at subparagraph 2. And of course, this is a case in which fresh evidence has been admitted on Ladin-Marshall principles. Paragraph 3 provides that an appeal will be allowed if the decision is wrong or unjust in the sense described. And justice here requires a legally cogent examination of the material evidence, particularly the evidence upon which a party's case is founded. Paragraph 4 of the rule demonstrates that the Court of Appeal has an originating jurisdiction to decide for itself what inferences of fact can be drawn from the evidence. And as we will see in the context of DATEC, that provides guidance as to the scope of the appellate court's responsibility in an appeal of this nature. So with that in mind, I propose to make submissions as to what the Court of Appeal in fact decided. And it's helpful to strip out what the Court of Appeal did and did not decide. So our first point is that the Court of Appeal did not conclude that the judge ought to have found that bribery was established. So the issue of bribery and its legal consequence is wholly unaffected by the Court of Appeal's judgment and is a matter for the retrial. The Court of Appeal did say that the torture issue should be determined before bribery. And that is because of the pleadings, the arguments, and as a matter of logic, when one has two facts in issue of this nature. And I appreciate that begs the question in respect of facts in issue, and I'll come back to that. The Court of Appeal did conclude that the judge's conclusions on torture had infected his reasoning on the bribery issue to a limited extent. However, that infection did not determine the appeal. So see judgment, paragraph 73 at MS 204. This appeal turned on what the Court of Appeal described as the crucial issue. And the crucial issue is set out at paragraph 74 of the Court of Appeal's judgment. so MS204. And the Court of Appeal said HNA's main challenge under this heading was that the judge simply never asked the right legal question, namely what weight he should attach to the admissions. And then the Court of Appeal goes on to set out at paragraph 74 what further necessary and relevant questions would be triggered by that. I don't propose to read that out. That sets out the further points which were of critical importance in terms of HNA receiving a fair hearing and a fair treatment of the submissions that it was advancing to the judge. On this further appeal, Shagang do not challenge the Court of Appeal's statement that the weight to be attached to the admissions was indeed a question that the judge had to ask himself. And Shagang do not suggest that the judge in fact asked and answered that question. So we say that Shagang has not challenged this at all as part of their appeal. This wasn't in the notice of appeal and is addressed fleetingly in the written case. We say that that was indeed a necessary question. And we say further that the judge did not ask or answer that question. If the Court of Appeal was right about that, and the judge did not ask or answer that question, we say the only conclusion that can follow is that he did indeed commit an error of law. And that would be sufficient to dispose of the appeal. Because the authorities relied upon by Shagang, such as Carlisle and RBS and McCready, have no application in this particular context because they are dealing with a different problem. Those are cases where the Court of Appeal substituted its own factual findings for those of the judge. But here, the Court of Appeal did not do that. The Court of Appeal simply identified a critical omission in the judge's reasoning, which was necessary for his own factual conclusions. My Lord, Lord Hampden. Sorry, my Lord.
You say the judge didn't address the weight to be given to the admission evidence, but the only evidence of bribery was the admission evidence, wasn't it?
Yes.
So in determining whether or not that was bribery, he must have been taking into account that evidence.
So he must have taken into account that evidence, yes. But what he didn't do is ask himself the question, why is it that multiple individuals have made admissions of bribery against their own interests? Why is it that I can confidently disbelieve that evidence that's before me? So
it's not that he didn't consider it, it's the detail with which he failed to consider it. Is that the complaint?
Well, he didn't consider why it is that it should be rejected. So he knew it existed. And when we look at the judgment, we'll see that he records the fact of the admissions. But what he doesn't ask himself is, in light of those admissions, why is it that I can say that those admissions are unreliable? That is simply omitted. Now, so we say, my Lord, Lord Briggs.
Lord Hampden, the judge plainly did have on his desk the confessions, I think I prefer to call them, confessions, admissions, it doesn't matter which. And he compared and contrasted their import with the commercialities of the case, the state of the market, things about the need for urgency, and so forth. Is that not a weighing process where you weigh testimony, whether it's hearsay or oral testimony, against the objective realities in the background?
So that is part of the weighing process. So we accept that to some extent, market conditions are capable of being a relevant factor, but they don't go anywhere, we say, in terms of demonstrating why it is that admissions fall to be themselves disbelieved. So why are the admissions false in light of the market conditions? This is the omission in the judge's reasoning. So the market conditions go to the overall propensity or probabilities of the bribe, but they say nothing about why people are falsely confessing to bribery. Lord Barrows.
I thought Shagang, at least at an earlier stage, had indicated, I think they articulated 9 reasons, and several of them were ones that, on any basis, you would say, went to the reliability of the admission stroke confession. So things like the fact that a lighter sentence appeared to be possible if one pleaded, the fact that there was no lawyer or representative present. So weren't there certain of the factors that Mr. Justice Knowles actually adverted to that you would, on any rational basis, say were weighing up the reliability of the evidence, irrespective, reliability of the confessions, irrespective of whether obtained by torture? True it is, he didn't say, in so many words, I am now assessing the weight of the confessions. But by implication, isn't that what he was doing?
It may be that by implication he had in mind certain factors which are capable of going to the overall likelihood of the bribe. But what he doesn't properly do is deal with the fact that he does in fact have 10 admissions before him from 3 different individuals, which on his own approach need to be treated as unreliable for some particular reason. So the missing piece of the jigsaw is, well, what is that reason when one has a series of confessions, stroke admissions of this nature? On their face, they do in fact demonstrate bribery. How is it the judge can say, notwithstanding all of that, I'm going to reject those confessions as being unreliable? And market conditions evidence simply doesn't go to that. Lord Barrows.
With respect, I'm just going to throw the same point back at you, that I would accept that some of the reasons he gave were simply concerned with whether a bribe was likely or not. But some of the reasons surely were entirely concerned with how reliable the confessions might be. And I can't at the moment just understand why you're saying he was giving no reasons for the unreliability or reliability of the confessions if one rules out torture. I mean, why, for example, was he talking about all this leniency of sentence? What was the relevance of that if he wasn't going through a weighing up process?
Well, it is difficult to try and improve the judge's reasoning on this because he simply doesn't tell us. So if the position is, well, the only logical reason to refer to market conditions is because they somehow go to the reliability of the admissions, then he needs to explain why that follows as a matter of judicial reasoning, because it may go to the reliability of the admissions or it may go to something completely different. It may simply go to the overall circumstances of the bribe. And bear in mind that, as we'll see on the pleadings in a moment, that point is actually only advanced by Shagang on a causation argument. So they say that the market conditions demonstrate that the bribe had no causative effect, but it doesn't actually go to the reliability of the admissions in the way that Shagang argued it. My Lord Legate.
Going back, I think, to Lord Hamblin's point, am I right in understanding that there was absolutely no other evidence put forward of bribery apart from the admissions or confessions, so that the issue of whether there was a bribe and whether the confessions were true were, on the facts of this case, one and the same issue?
Well, possibly one and the same issue. It's difficult to understand quite what the conclusion actually is. So is the judge saying, well, I express no view as to whether those admissions are true or false, but I nevertheless conclude X in respect of bribery? Or is he saying something slightly different? Because I certainly accept that it would seem to follow that insofar as the case is essentially based on the confessions, because HNA's case failed, it must follow that the judge had some doubts about the confessions. I accept that. But the problem is not so much the conclusion, it's the process of judicial reasoning that led him to that conclusion. So what is it that he said was sufficient for him to say that those confessions should be rejected as unreliable? And that's what the judgment simply doesn't do. So my clients, having advanced confessions stroke admissions as the basis of their case, need to understand why it is that the judge says those confessions are unreliable. And he does not do that, other than by what I would respectfully describe as a slightly complex and convoluted process of elimination, which is being explored before this court now. So we respectfully say that the judgment cannot be defended on the basis that he must have concluded X, Y, Z, because he simply doesn't say that within his judgment. That's the fundamental issue that the Court of Appeal has identified here. We do not say that the overall conclusions in respect of bribery are not open to a judge. That's a matter for the retrial. So this case, this appeal, does not go as far as VATEC when the losing party seeks to persuade the appellate court effectively to reverse the trial judge and have judgment in its favour. We say that ultimately the retrial judge may well reach the same conclusion as Mr. Justice Knowles. Of course, we say he shouldn't, but that's not enough to save the judgment here, because the absence of proper analysis betrays an error in the sense of the relevant procedural rule. Is simply not enough for an appellate court to seek to infer the conclusions as to reliability of the admissions that this court is canvassing with me now. So my lords, we say the questions that arise are essentially this: was the Court of Appeal right to identify the question and the crucial issue in the way that it did? What was what I have outlined a necessary part of the judicial reasoning of the judge in this case? And was the Court of Appeal right to conclude that the judge did not adequately answer the question that he should have asked? So dealing with the first question, did the judge need to ask the question about why it was that the confessions were to be rejected as unreliable? And we say that it is obvious that he needed to ask that question. The starting point is that that was the premise of the pleadings. So see, please, Shagang's particulars of claim at MS 355. That pleads the charterer's liability and the guarantor's liability from paragraph 17 and 18 at MS 361. See then, please, HNA's amended defence at MS 364 in paragraph 4A, which is at MS 364. So HNA pleaded bribery. So paragraph 4, capital B, A, pleads admissions from GIA H and GIA T. Paragraph 4B, subparagraph B, pleads admissions from Mr. Zhu. And paragraph 4BD pleads an admission from Mr. Shen. So each of these admissions separately evidence the bribe. And we say that if the judge were to reject the bribery case, he needed a reason to disbelieve and reject each of these admissions, confessions. My lords, for completeness, rescission is pleaded from paragraph 19A, which is MS 370, through to paragraph 27. And Shagang's reply appears at MS 376, and Shagang plead torture by way of the re-amended reply. So see, please, paragraph 1C, subparagraph 5C at MS 380. One sees the pleading of Mr. Zhu's confessions as being given purely in order to stop the painful and inhumane treatment. Then see, please, paragraph 1C11C at MS 382, where Shagang pleads the torture exclusionary rule in relation to Mr. Zhu. Under paragraph 1C12C Roman 1, Shagang pleads the torture exclusionary rule for Jia T and Mr. Shen. Now, I said that market conditions was in fact pleaded as effectively a causation point. I'm not taking a pleading point for the purpose of this appeal, but just to show you that, to make the point good, that's at MS 378. And it's paragraph 1B2 at the top of that page. One sees that the market conditions are pleaded by reference to a causation argument, which we say, for reasons now outside the scope of this appeal, are bad in law. But it is notable that Shagang did not advance those reasons as matters that went to credibility of the admissions. Note also on the face of the pleadings that leniency was not identified in Shagang's pleading as a reason for unreliable confessions. So, my Lord Lovebriggs.
I may be quite wrong, but my recollection is that one didn't have to, and generally didn't, plead matters that go to the credibility of testimony that's going to be advanced in support of the other side's pleaded case.
My Lord, I accept that, and very clear, I'm not making a pleading point here. I'm simply outlining the basis on which Shagang presented their arguments, because their argument at trial, in fact, corresponded to their pleaded case.
How did the leniency come into the argument then?
I'm sorry, Madam.
How did the question of leniency arise in the argument?
The question of leniency arose effectively through submission. So the fact of leniency was identified in the documents. And then from there, it developed to some extent in the judgment, as we'll see, as a factor in respect of the admissions, confessions. But as I think Shagang accepted, certainly in the Court of Appeal, the trial judge, Mr. Justice Knowles, did not find that leniency was a reason for confessions being made which were untrue.
Yes, but there was evidence from those who were said to have confessed that leniency influenced their decision. Was that their stance in withdrawing the confession?
Well, there was evidence that the people who confessed would receive leniency. So the law of China, much like the law of England, does give a benefit to people who confess crimes that they have committed in terms of leniency. So it goes that far in that there was an acceptance and a recognition that if you confess to something, then you will receive a more lenient sentence, as is the case in England. So that's as far as the evidence went.
None of the witnesses didn't say that was why they made the confession, which they later said was untrue.
No, they certainly did not say we falsely confessed only because we wish to have a more lenient sentence. So, and it's that critical distinction which the judge certainly did not make in his judgment.
Thank you.
Sorry, I may be wrong, but I thought that there was evidence that one of the individuals, at least, I think maybe Mr. Zhu, explained why he had pleaded guilty, despite at that stage having retracted his confession and said that it wasn't a truthful confession. And the explanation he gave as to why he was still wanted to plead guilty to his lawyer was that he was hoping to get out of prison quicker.
Well,
isn't that the gist of some of the evidence that was given?
My lord, perhaps I'll pick up on, well, I will take the court into a bit more detail as to what's actually within these confession documents. None of this appears on the face of the judgment. So certainly was not part of this judge's reasoning that was a reason for false confessions. But we can certainly go through the detail of what was actually said in each of the individual confessions, because a central difficulty that we have is that they are not addressed in the judgment. There are 10 of them, and at best there's a passing reference to the fact of Mr. Zhu's guilty plea, and some comments made in respect of that. In respect of G.A.T., there appears to be an acceptance that the admission was indeed made, but Mr. G.A.T. was told to give the money back, and the judge doesn't quite then reconcile that particular fact with the overall conclusions that the admissions are false, because it seems to be he accepts it to be true, albeit with a caveat. But we'll look at that. My Lord, Lord Hamlin.
Just picking up on Lord Legate's point, the judge does refer to paragraph 38 of the judgment, how Mr. Zhu explained decision to adhere to his earlier account because it would lead to a much reduced sentence.
Yes.
He got out within a month or so of the hearing, didn't he? Because he'd been detained quite a long time already.
Yes. So there is no doubt that leniency would result in a lower sentence. The issue is, well, what does that
This is a much more specific point which the judge is making in relation to Mr. Zhu.
So the specific point he is making concerns the guilty plea. So this is, I think, the 5th of the confessions by Mr. Zhu is a confession made in the face of the Chinese court with his lawyer there. And there's a reason given for that, or there is an explanation on the face of Mr. Zhu's evidence that there would be a much reduced sentence.
Because he was saying to the lawyers, he'd already said that I didn't do this. I was made to confess, but nevertheless, I'm going to plead guilty for these reasons.
Right? I don't know if I was taking that from paragraph 38 or from...
Well, no, the bit prior to that was when his earlier interviews with the lawyers, where he set out his position. I think with the in December interviews, he is explaining why, despite having said that, he's still going to plead guilty.
Yes.
So those are referred to at paragraph 37 as well.
Yeah.
There is no doubt that at various times, Mr. Zhu does say, he makes the admission, he says, yes, I am guilty of bribery, and he also says, no, I am not. So there is that, those different versions of events that are being advanced by the individual. So it is right that a judge conducting all of this can explain why one is preferred over the other. Indeed, we say not only is it right, that is a necessary and obvious step that the judge needs to conduct when one has evidence of this nature. But he doesn't do it. And that is our fundamental criticism of this judgment. So we are not suggesting that there is no evidence there which is capable of undermining the reliability of the admissions. There is evidence which is capable of doing that. It's just not properly examined, my lord.
Paragraph, sorry, can you hear? Paragraph 97, he does expressly refer to that. Mr. Justice Knowles precisely refers to that point. However, the possibility of a large difference.
Well, there's a number of points which I will make by reference to paragraph 97. It may be easier for me to take them all in one go tomorrow, But we say that the reference to a possibility of leniency in circumstances where the judge did not find that leniency was in fact a reason for people to falsely confess to something is not enough, because it isn't. Anything is a theoretical possibility. What the judge needs to do is go further and say, well, was that in fact a factor here which had relevance and significance in terms of the job that I need to conduct, in terms of weighing up the admissions evidence, and simply identifying other possibilities that are out there without actually examining whether in fact they did have any particular impact, it isn't sufficient for the reasons that the Court of Appeal gave.
Well, Mr. Brown, I think we have come to 4 o'clock, so we will allow you to redevelop these points in your own coherent way tomorrow morning. So the court will now adjourn until 10:30 tomorrow morning. Thank you very much.